Um, Kia ora and welcome everybody. I'm James and I'm one of the lawyers at the Commission specialising in consumer credit. This afternoon I'm going to talk about the obligations you have as lenders around disclosure. As you know, it is a really important area, one for borrowers because they need to be able to make informed choices and understand their rights. For lenders, because the consequences of getting it wrong are significant. And for the Commission, because we continue to see examples of disclosure that is being done wrong. So what am I going to cover today? Well, as much as I can in 15 minutes, but I'll start with an overview of the different kinds of disclosure. So that is the main kinds: initial, continuing, variation, request, and standard form disclosure. I'll then move on to disclosure to guarantors and disclosure when contracts are transferred. Finally, I'll move on to the three more recent disclosure requirements, the ones that came into effect on the 1st of December 2021. I'm talking here about disclosure around financial mentoring, dispute resolution services, and disclosure that must be made prior to debt collection. And finally, I'll talk about why getting it right is so important and the consequences for you as a lender if you get it wrong. But before we begin, there are a couple of things I just wanted to stress, even if they do seem a bit obvious. First, it's not enough to know and follow sections 17 to 26A of the Act when you're undertaking your disclosure obligations. You also need to understand and abide by the regulations. These now set out some prescriptive disclosure requirements. You also need to take into account the Responsible Lending Code for reasons I'll touch on later. Second, I'm covering a lot of content very quickly today, but this information is available in the Commission's Disclosure for Lenders Guidelines. These were updated and reissued in April this year, and a link to these is in the brochure that has been sent out. Finally, just a bit of a reminder, there are example disclosures in the guidelines, such as for variation disclosure. There is also model initial disclosure statements in Schedule 2 of the regulations. These are both for revolving credit contracts and non-revolving credit contracts. Now, you don't have to use these model disclosure statements, but at the very least, they are set out in a CCCFA compliant format if you do choose to use them. So let's kick things off with initial disclosure. So this is section 17 disclosure. You need to make as much of the information in Schedule 1 that applies to the contract available to the borrower before the contract is entered into. Schedule 1 contains things like total interest charges, if they're ascertainable, and a borrower's right to cancel the credit contract. Next, continuing disclosure, which is section 18 disclosure. As a lender, you need to make periodic disclosure of as much of the information set out in section 19 as applies. Now, this is usually every 6 months, but it shortens to every 45 days if it's a revolving credit contract. There are some exceptions to this, but most notably, it's if the borrower actually has access to up-to-date information on your website. Then there is variation disclosure. So when there is either an agreed change to the contract or when in certain circumstances, you and a lender are permitted to change the contract unilaterally. So looking just at agreed changes, the obligation is to disclose full particulars of the change and any other information prescribed by the regulations. So what does that all mean? Well, we at the Commission say full particulars of the change includes the change and its effect, together with the effect of the change on any of the Schedule 1 information. And the regulations, so Regulation 4F, now expressly state what must be disclosed where the change affects the credit limit, annual interest rate, credit fees and charges, total interest charges, or the payments required. And just a quick reminder about timing. With agreed changes, you need to provide disclosure before the change takes effect, and that includes if the change is due to a hardship application. There are some circumstances, however, when this is not the case, and this is if the borrower's obligations are reduced, if they're given more time, or security is released. Then the disclosure can be made within 5 working days of the change taking effect, or as part of continuing disclosure. And just to be aware, variation disclosure requirements are slightly different again if you're a high-cost lender. Turning to request disclosure, this is where a borrower or someone acting on their behalf asks you for copies of documents, such as the contract and a disclosure statement, or even specific information. A borrower can ask for examples about the effect of a part repayment, the unpaid balance, charges that apply on part prepayment, and the amount to fully repay the debt on a specified date. And this needs to be provided within 15 working days of the request, unless the contract ended more than a year before the request, or the information has been provided to the borrower in the last 3 months. Taking a step back, there are disclosure requirements that kick in even earlier than initial disclosure. So these are the standard form contract terms and costs of borrowing disclosure. What I'm talking about here is sections 9J and 9K of the Act. So your standard terms and conditions and the costs of borrowing, which includes your credit fees, your default fees, and interest charges, must be published on your website if you have one. There has to be a notice displayed prominently at your public premise stating that the standard form contract and the costs of borrowing are available on request. And finally, if somebody does request the standard form contract or the costs of borrowing, these are to be provided free of charge and immediately on receiving their request. Turning now to disclosure to guarantors and disclosure on transfer, we thought we would cover this area as we're seeing an increase in complaints. As with borrowers, there are initial disclosure and variation disclosure obligations. So to start with, you need to disclose to the guarantor the terms of the guarantee and the key information in Schedule 1 that applies to the contract. And this is before the guarantee is entered into. As well, you'll also need to disclose the key terms of any subsequent contract that the guarantee applies to, and this has to be done within 5 working days of that contract being entered into. If the contract with the borrower is changed to increase the borrower's obligations or to reduce the time for payment, you also need to provide variation disclosure. That's the full particulars of the changes to the contract and any other information the regulations require to be disclosed. Again, this needs to be done within 5 working days of the date the change is agreed, or if it's a unilateral change, within 5 working days of the change taking effect. However, you don't need to disclose changes to the guarantor if you can't reasonably locate them, and I'll talk about this in a moment. But first, very quickly, I'd just like to run through transfer disclosure. As you know, if a loan is assigned or transferred by the operation of law, then under Section 26A, the lender must, within 10 working days of the date of the transfer taking effect, advise the borrower and any guarantor about the new lender. This includes the new lender's name, address, and contact details, their FSPR number, and their dispute resolution scheme contact details. You also have to provide the date of the transfer and the impact, if there is any, on the borrower, and that the transfer does not otherwise affect the terms of the loan that the borrower entered into. There are some exceptions to the need to make the disclosure. And as I just said, most relevantly, it's if the borrower or the guarantor cannot reasonably be located. Now, sometimes we're asked what this means and what steps does a lender have to take to reasonably locate a borrower or guarantor? Well, it's always going to depend on the circumstance. So what is reasonable given the fact scenario in question? But the Commission has put some guidance on this in the Disclosure for Lenders guidelines. So if this is something that is troubling you, you can check out the guidelines and hopefully that sorts it out for you. I now want to talk about the 3 disclosure obligations that came into effect on the 1st of December 2021. I'm going to spend a bit more time on these because they are relatively new and perhaps you're not as familiar with these as you are with the other types of disclosure that I've just covered. So the first relates to financial mentoring services. If after December 2021, your borrower defaults, exceeds their credit limit, or makes a hardship application, you then must disclose a statement about the availability of free and confidential advice from an independent service, the name of a building financial capability service funded by MSD that provides such a service, and of course the contact details for the service. Now, it should be an FM service that is local to the borrower or a national one if no appropriate local one is available. We know lenders have had some queries about this, and if you are referring the borrower to a national service, it is fine to refer borrowers to FinCap or MoneyTalk specifically if this is what you would like to do. You might also want to note that in the responsible lending code, that recommends that the FM services information also be included with payment reminders. So this is in addition to the financial mentoring services disclosure. The second requirement relates to dispute resolution services. This applies if your borrower makes a hardship application, complains about enforcement action, or makes any other complaint covered by the regulations. So it is quite broad. It requires you to disclose information about your dispute resolution scheme, precisely what is set out in the regulations. But in summary, it's the name of your dispute resolution scheme, a statement that the borrower has access to the service, that is free, it's independent, and that it may help to investigate or resolve the complaint for them, and also the contact details for the service. And finally, the third newish disclosure obligation relates to debt collection. Before you start collecting on the debt, you now need to disclose certain information. That information is set out in Regulation 23, and it includes information that will help the borrower identify the credit contract, a statement about the debt, information about the debt collector, a statement about hardship rights, and information about a free and confidential advice being available from a building financial capability service. And that's all of the types of disclosure that I wanted to cover today. I'm now going to turn to the consequences of inadequate disclosure and why all of this is so important. For our part, we're continuing to see issues with the disclosure some lenders are making. And from your perspective, getting disclosure wrong can give rise to significant civil and criminal consequences. So it's worth a refresh on the obligations that you have. So let's talk about those consequences. Let's start with the fact that if you don't follow the requirements for initial and variation disclosure, you can't enforce the contract until you correct the disclosure, and you can't recover or retain any interest or fees for the period of non-compliance. What this means is that you will need to return all of your fees and interests to a borrower if your disclosure isn't up to scratch. Now, this sounds harsh, and it can be, but since December 2019, you've been able to argue that you don't have to give it all back, but you have to go to court to make that argument. A second and significant consequence of getting initial disclosure incorrect is that the borrower can cancel the contract without penalty, although some fees and interest may need to be paid depending on the contract. The court, if the Commission takes proceedings, can also make a wide range of orders to remedy a disclosure breach. So these are orders for extra damages, refunds or compensation, and repeated non-compliance could potentially result in an order banning a lender. Now, any of these orders that are made by a court will also be taken into account in reassessing an existing certification status or considering future fit and proper person certification applications. Then there are infringement offences. The Commission can issue infringement notices if it has a reasonable ground to believe a person has committed an infringement offence. So this brings us to the end of our whistle-stop tour of disclosure. I hope it was useful. And just a reminder to make sure that you read and take on board the Disclosure for Lenders guidelines and the regulations as updated last year. Thank you all for your time and your attention, and I'll pass you back